that situation is to try to get the law changed and not lie and sit on a jury, you know, and say I can follow the law, but then not really follow the law because you don't agree with it. So I have a different, different view on it.
Since self-defense is a right of every citizen under the Constitution,
under the law, and the common law and the law of the California Penal Code recognizes the right to self-defense.
right. Understanding that, why, upon what basis in law does the Sheriff of Santa Clara County seemingly arbitrarily deny the right to carry a concealed weapon if the applicant uses that reason, self-defense, as the reason that they want the permit?
That's an easy question for me to answer because I'm not the sheriff. And so I don't. So I know the sheriff, Lori Smith. I don't give out concealed weapons permits. She's the one that does, and that she's entrusted with the authority to issue concealed weapons permits. I actually don't know the basis on which she makes those decisions. There are a few employees I know within the district attorney's office that have concealed weapons permits, and we have certain policies about under what circumstances they can carry that out.
Doesn't that seem like a significant infringement on the Second Amendment for her to be doing that?
It might be.
It might.
I mean, I just understand. I'm not the Ninth Circuit or the California Supreme Court, but really what you're asking, I think, is a good legal question, and it sounds like you're asking, what if somebody or a group of individuals were to sue the sheriff and say that you are violating this group of people's Second Amendment rights to bear arms, and that's something that a court would decide. It's not something that I would decide, but it's something the court would decide. Yes.
What I'm really curious about that situation is, and I'm sure he's saying the same thing, is long before our current sheriff was voted in, it's been a practice in this county to take the application to someplace. It's a joke. I mean, for us, set it on a file, and that's where it sits for ungodly amounts of time. I mean, you get no answer, you get nothing. Oh, it's in the system. Long before she was voted in. What's the answer to that? Or is that, I know I'm not being fair to ask you that, but that's what makes us feel that,
I understand. I think the question's fair. It's just it's not one that I can answer.
Well, we see things that are going on that are absolutely corrupt. You don't see things that we see, and you don't think they're relevant for your position in office, which may be true. But we have concerns, and we feel powerless. When we pay our fees, we sit and we wait, we don't get an answer, and then later on we find we're denied. Just like jury nullification, which is a right. I suggest you read the Constitution again. But these are the issues from our perspective here.
I understand, and what I'm saying is that I think that the avenue to address those concerns is through either the courtroom or the ballot box. I think that's really how to address it. It's not something that in my role as district attorney that I deal with. In the way back.
Question about returning firearms to their rightful and registered owners. We've seen multiple gun turn-ins, and we've seen a full gamut of what's turned in for the trinkets that are offered in return. What is the official policy for checking to see if the firearms turned in are evidence of crimes committed, and what efforts are made to return them to the rightful owners before destruction?
So, are you talking about gun buybacks when the police department says we'll buy guns and we'll give them to you with sort of no questions asked? Is that
the one sponsored by the Sharks and other organizations in cooperation with the police force?
I don't know the answer. I don't know whether what efforts. Well, let me put it this way. I know that police department will check to see if those guns were involved in any crimes and try to use that to solve cases. As to whether the police department then makes efforts to return if the gun was stolen from someone, return it to their owner. I don't know what efforts they make in that regard. I know that in criminal cases, when we seize guns from individuals, depending on how the charges are resolved in the case, sometimes the guns are returned if the charges are dismissed, and guns aren't illegal. If the charges are, if the person's convicted, the guns are destroyed. That's typically what happens.
If a firearm is picked up in something like that, and the police should know that it's stolen just by virtue of the fact that looking at the serial number, if the reports have been filed and all, would it not be a criminal offense on their part to not do their duty and return it to the previous owner? Wouldn't that be something they would be responsible for?
I don't know if I would characterize that as a criminal offense.
It's stolen property. They're in charge of it at the time that they take it over.
I understand. First of all, I don't know that all the guns that are returned always have serial numbers. Sometimes serial numbers are removed from the guns to make it more difficult to
Yeah, but
trace
they
them.
can usually be restored because the people who move the guns know that it's.
You know,
Ladies and gentlemen, this is not a debate. Give them a chance to answer.
Oh, it's okay. I don't see why the police wouldn't make those efforts. I think that for a person who's had their guns stolen, I mean, this is just sort of, I would say, kind of helpful advice to, contact the local police department to see if, the guns are there. I understand guns can be moved into different cities and different counties, but a good place to start is the local police department and ask them and see what they can do about that. I mean, I don't believe it should be treated as any other example of stolen property. So sometimes it's easy to figure out who property was stolen from, sometimes it's more difficult. And I understand probably with guns, it should be somewhat easier if there's different forms that were, filled out. I understand.
I would just think that.
Tom, please, there's other people with questions, okay, please.
What's your conviction rate and what percentage of your cases you plea bargain to a lesser included charge?
Wow. First, so the question was, what's our conviction rate, and what percentage of cases do we plea bargain? So, first thing is, I don't use the term plea bargaining. We negotiate settlements.
Spoken like a true politician.
The reason I say that in part, I mean in part would be funny, but in part, bargaining is something that you do when you buy a car, which I just did. So that's bargaining. But when we're talking about figuring out what a just and appropriate sentence is for an individual who's committed a crime, and a sentence that fits the crime and protects the community, it's really a negotiated settlement. So I can say that our conviction rate in felonies is above 90%, but that includes cases, that number, and I don't know whether it's 91 or 92 or whatever, that includes cases that may have been charged as a robbery felony, but then were settled for, a grand theft felony. So I can't give you an exact percentage. I say that our philosophy in charging cases is to charge what we can prove and to prove what we can charge. And we try to be very careful about not overcharging cases. And the reason I think it's so important that we don't do that is we as prosecutors have enormous power. And we can, the police can arrest you, but if one of our lawyers doesn't take a pen and sign a complaint or sign an information to be filed in the court with criminal charges, you will be released. So because of the use that in a way, that, forces someone to plead to something, just because they wanna get out of jail,